Car crashes. Unfortunately, they do occur, and unfortunately, people suffer injury. Many times, obviously, the person who suffered injury brings claim against the person who was at fault. What happens if the person who is at fault was really in a condition that they were not or should not have been driving, possibly as a result of somebody else's conduct? Well, that brings us to this week's case. Involved an unusual set of circumstances. There was a man who was out there on the highway. He was an employee for a company that had him work a 22-hour shift. 22-hour shift. He was dog tired. Driving home, fell asleep, slammed into another vehicle, bad injuries. Guy that suffered bad injuries brought claim, and not only brought claim against the fellow who was driving, but also brought claim against his company. Now, there were two bases that he used to bring this claim. One was he said that the guy who was driving really was working for his employer. Even though he was on the way home, for all intents and purposes, it was the conduct of his employer requiring him to work 22 hours that took him to the highway at that time and place. And therefore, the employer should be responsible because that guy, for all intents and purposes, was an employee who was there because of his employer requiring him to work 22 hours. The other argument, second argument, was that he and his employer were responsible, and especially his employer was responsible because his employer knew he was highly fatigued and he still let him go out and drive. It's similar to the argument that a bar would let somebody go out and drive after they knew the person was very heavily intoxicated. So, what happened? What happened? Well, the guys on the other side said, the employer said, we're not at fault because our employee was off the clock. He wasn't working for us at the time. He was just going home, and therefore, since he wasn't in the course and scope of his employment, he is someone who's on his own. We're not at fault. Other argument they made was to say, hey, you know, the guy was tired, but how badly tired he was, we really don't know. Different people respond in different ways, and we can't babysit everybody, and therefore we're not responsible for that. Well, this case went up on appeal. This was a Maryland case. It went up on appeal, and what the court did there is they came away saying, you know what, with regard to the first argument, you're right. Employer, because he was off the clock, that employee was not working for you, and therefore you're not responsible since he was your employee because he wasn't your employee. As to the second argument, that he was highly fatigued, you let him go out, start driving even though he was highly fatigued, well, there was nothing to indicate that he was so fatigued as not to be able to operate an automobile. Everybody responds to stress differently. Everybody responds to deprivation of sleep differently. And therefore, we're not going to hold you liable because the facts do not indicate that his condition was such that a reasonable person would have prevented him from driving. And therefore, Mr. Plaintiff, as to your cause of action, your claim against the employer, it's gone. Neither of those causes of action work, and the employer is off the hook. Okay, so what do we learn from this? What we learn from this is one very simple and straightforward thing, that for someone to be liable for the acts of their employees, an employer to be liable for the acts of their employee, the employee must be doing something on behalf of the employer. Here we had someone who was just going home. They weren't doing anything on behalf of the employer. Second, we find that with regard to a condition that someone is exhibiting at the time that they are going out on the road, well, even though the person may have had some contribution to them being in that condition, in this instance having them work a 22-hour shift, that individual will not be responsible for the conduct that basically stems from that condition unless they had a reasonable basis to believe that that condition would impede them and cause them to harm others. Okay. Well, we bring you this case as we bring you cases every week so you understand how the law works. I'm David Allen.